Good morning, everyone. Thank you for coming. If you're here for the land class, you came to the right place. I'm here with our managing broker, Mike Briggs, will lead us through this buyer side land transaction to kind of give you a little basic information on what you might need to know if you were going to write an offer on a piece of land. So
this is part two. Some of you were here last week for part one, where we talked about the NVAR, exclusive right to sell unimproved land, listing agreement primarily. This is going to be primarily focused on the on the sales contract for land, NVAR forms. People who will be watching this in the future from the Nest, streaming or YouTube or whatever, can know that the concepts that we're talking about, the fundamentals, apply across the region. You know, the forms may be a little bit different, the GCAR or MAR or wherever you are, but know that this is about the fundamentals, mostly about the paperwork, but some color commentary, and then some of what you need to know as a buyer agent in this session. And this, we're delighted to say, will be followed by a more in-depth class with a special guest, land engineer, John Manganello, who is a longtime friend. He's the owner of Land Development Consultants, Inc. in Fairfax. He's also a real estate broker. He has agreed to join us within the next 30 days, certainly by the end of the year. And so that'll be good because you'll hear it straight from an engineer as to some of the issues that, some of the more technical things and procedural things that people deal with when having to interact with the county offices, and something that's not just a cookie cutter single lot to build a house on. So look forward to that. We'll keep people updated. And in the Nest as well, we'll mention this again at the end of the class. In the Nest, we have an outline called Listing and Selling Land.
I printed that out too, so it's available there on the stand.
This is a 3 or 4 page bullet outline, which has a lot of good food for thought. Many of the points on that document are what we're going to be talking about today. And it's also, in addition to that outline, there's a full binder of additional information that's more in depth, including a feasibility study that John Manganello did for me on a project right over in Vienna. Land Development Consultant Report. It's just one example of a feasibility study, engineering report for highest and best use for a particular piece of property. So that's in the Nest as well. And stay tuned.
Under, what's that, broker resource?
If you go to the library and just type land in the keyword search, you'll find these 2 documents, the outline and then the full binder. There's also in that packet a nice article on well and septic, Realtor's Guide to Well and Septic. If y'all haven't seen that, it was published many years ago. It's available through NVAR.com, but I have it saved as part of that binder in the Nest as well. So a lot of good information about well and septic issues. Okay?
All right.
Want to kick it off with the
we can
contract?
Too. So we're going to be talking mainly about the NVAR contract K1209, and this is the sales contract for unimproved land. So these contracts, of course, as even the residential sales contract, they're kind of all set up the same. Top part is your contract date, who the contract is between, buyer and seller, and what companies are involved, listing company, buyer agent company. Then you get to paragraph 1, of course, for the real property. Here you're going to fill in, to the best of your ability, what the legal description is of this property. Most of the time you can get that from the tax record. And then sometimes you may be doing a contract for multiple parcels, so you may have to note multiple parcels in this one contract because maybe they're selling 2 or 3 parcels together. So you would want to put that all in paragraph 1. And then moving down to paragraph 2 would be your improvements, chattel, and or equipment included. The following items would include, so if there's anything that conveys with this particular piece of land, shed, maybe there's an old mobile home on the property or trailer or whatever.
Or a dilapidated dwelling.
Right. So you would add those things in. That would be would also convey with this particular piece of property.
Steve, let me interject.
Yep.
A lot of times agents will ask us, they're looking at a piece of property that has a tear down house on it, and their buyer absolutely is looking to tear down and build new. They're not looking to do a renovation or add on or anything. So and they ask, which contract should we use? Should we use the sales contract for unimproved land, or should we use the residential sales contract, the standard resale contract? And it can depend. You could use either one in that case. You could use the residential sales contract. But if the intent of the buyer is to tear it down for sure and build, or tear it down and subdivide or do whatever they're going to do, especially if they're going to be getting acquisition, construction, financing, I would say go ahead and use the sales contract for unimproved land, even though there's some improvements on the property, but write them in to that chattels and equipment line, okay?
If the property was built prior to 1978, would you need lead-based paint?
I would still use the lead-based paint disclosure. If you're a listing agent and if you're a buyer agent, if there's a dwelling, if there's structures on it that, are dwellings, not necessarily sheds or anything, but that are built prior to 78, yes, I would go ahead and do that. Brian has a question. Wait, hang on, Brian. Need the...
I'm going to do the Elks Lodge on Tuesday nights. And paragraph 2 looks pretty meager. If you go to a place that has farm equipment conveys or what have you, are we allowed to go to addendum 1 and put the whole list there?
Absolutely.
Okay, that's all I want to know.
Absolutely. All right.
All right, moving on to pricing. So next paragraph in here is paragraph 3, price and financing. The first thing that you're really talking about here on pricing would be, oops, that's horrible. Oh, there we go.
Yeah.
Would be the sale price. So you'd want to, your buyer is relying on you to come up with a sales price so that you can make an offer for this particular piece of parcel or properties. And here is some factors that might help you determine how to weigh that in regards to coming up with a sale price.
Right. So these items on this slide here are pretty much taken from this outline that we talked about earlier that is in the nest. And Steve said he may have included it today. I don't know. Did you print these or include it?
Yeah,
you did.
I printed. No, I didn't print that. I print the. Maybe I did. I don't.
That's all right. So I had put this together a few years ago, and then a year or two ago, Dave Werfel and I did a little class similar to this in Fairfax office, but this is just designed to be food for thought, and we encourage you to go through that. This right here, 1, 2, 3, 4, about 4.5 pages or so, has a lot of useful information, whether you're a listing agent or a buyer agent, but including these items on how to evaluate, as a buyer agent in this case, what do you think is a reasonable price, regardless of what the listing agent may or may not have it on the market at, or it may be a property that's not on the market. Maybe you're dealing with a FSBO or whatever. So we'll go through them real quick. The first item there is, what is the buyer's intended use for the property versus whatever the current zoning and current use is. So remember, there's all kinds of uses. Different residential uses, different commercial uses, quasi-commercial uses. So it's all going to hinge. Value is in usually in highest and best use. And highest and best use is usually what's the highest density and classification allowed under the current zoning, or what does the comprehensive plan call for. If it's just for one house, if that's what you're looking at, we'll get into that. That's a little bit easier of evaluation than some of the other analyses that goes into what's this property worth. The next one, what could the property be used for? Yeah, residential, multifamily, commercial, industrial, farming. All hinges on what your buyer wants to do with it. Is there realistic potential for upzoning? Yeah, there we go. To a higher density residential or to a commercial industrial zoning classification. Is that important to your buyer? Is it subdividable? And if so, to what extent? If yes, does it appear to be by right? Does it look like under the zoning that it might be a by right subdivision? And that's usually, you start with, is there enough land under the existing classification to cut it into pieces? You got to have initial land area, minimum square footage per lot, and then you also have to have minimum road frontage. There's requirements in each zoning classification as to what the county's going to require for any subdivision for each lot, amount of road frontage and or allowable, approvable ingress, egress to the lots. Let's see, so if residential, what is the estimated max finished new home sale value based on area new home comps? One of the things that, when you're looking at individual lots, like infill lots for residential, obviously you want to go into MLS first and look for comps under land and lots. You'll find some, probably, depending on the area, but you might not find that much. And so then you want to start doing additional analysis, like try to search properties that have closed that were listed as residential and appeared to be aggressively priced, and they were teardowns because that could be a comp, right? It might not have been in MLS as a land or lot listing, but you can, with a little bit of work, you can conclude whether some of these other properties in the immediate area, in fact, were bought as teardowns. And so that is, when you have a teardown, it actually increases the cost of the lot, right? Because you have demolition costs, demolition and removal. You've got to get demolition permits for that sort of thing. So,
well, it could also reduce the cost, right? If there's already certain utilities already because of the lot.
Sure, absolutely.
Right?
Yeah, I mean, so if it's an infill residential lot that had a dwelling on it, that by definition pretty much means it's an approvable building lot, depending on whether there's public utilities, depending on whether there's good soil perk, if it has to be septic, all of that stuff. Let's see, going down on the list here, what is the price per square foot or per acre? In looking at your comps, that's another way to evaluate. If you don't have a lot of comps that are cookie cutter comps that are very, very, very similar, identical, you got to look at smaller or larger pieces of land that have sold. Try to get a price per square foot or price per acre, right? Obviously, price per acre is used a lot more with larger tracts of land. We talked about road frontage and by right ingress and egress. Does it already exist? If not, what would be required to bring a road in? Sometimes you see this with these older family subdivisions, property that's been in families for generations or whatever, and they've done these loosely defined subdivisions, or in rural counties where in the past the requirements were a lot less stringent than they are today, and you may have issues with the road or driveway. Who owns that? Whose land is it on? Is there a shared driveway easement or road maintenance easement or road maintenance agreement? All these things affect value. They can affect value. Are there already enhancements, improvements on the land such as road or driveway, any fencing, any structures, etc. Does the seller and or listing agent have a plat or survey of any type? Any soil or perk tests, well projections, etc.? As a buyer agent, you would hope that the listing agent and the seller are going to have something to give you, but oftentimes they got very, very, very little. So you got to ask, just because you don't see it in the MLS documents section or whatever, certainly ask the listing agent or the seller, have they done any studies ever? Do they have the original development plat? I mean, you can, in the declaration of any legal subdivision, you should see the original record plat in the land records, in the deed itself, but it could have been by meets and bounds many, many years ago, and it may not be so accurate, but ideally you have more than that given to you as a buyer agent in the way of boundary survey. You're usually not going to have topo surveys or other engineered, like wetlands studies, all that stuff, but see what you can get, because where we're heading with this is, and we'll talk about feasibility study in a little bit, but you're going to have to decide if you can't determine what you think reasonable market value is when you're wanting to put a letter of intent in or an offer. You got to talk with your buyer about how much money they're willing to spend if it's important to them on engineering to try to determine really what the value is. All right, then, so what do we have? What utilities are close by, and what are the estimated costs to connect? Most of the properties in our marketplace, local and more rural, have electric, right nearby or at the property, running down the nearest road or whatever. But public water, sewer, gas. Not only is there an issue of do you have to bring it to your property or is it already at the property, but what are the tie-in fees? Okay. Last one on this list, is the property primarily cleared? Is it wooded or both? What's the topography? Are there any streams or wetlands on the site? Depending, no matter what your use is, whether it's residential or commercial or quasi-commercial like a church facility, house of worship, or school or daycare center, or whatever the use is, obviously the topography and whether and the any wetlands on the property is a major consideration. It can really serve to devalue or limit the property. So,
Quick question on the utilities. Now, you see in some areas the utilities run underground, and then in some areas they're poles, right?
Yeah.
Is there a significant cost difference between the two if you're trying to evaluate that for your buyer?
I don't know, Steve. That's a good question. I've never faced that personally in the real world. Obviously, underground utilities, I would think are preferred, by like power, the underground power. You're going to see that obviously more in the urban areas, suburban areas, as opposed to out in the country. Obviously, most of the electric is above ground.
Microphone. Oh, go ahead in the back.
All right, so okay, we spoke about the utilities, right? If it is a new area or area where it is being developed right now, who do we contact to get the information regarding the estimate of how much it's going to cost? I guess if the utility line is pretty close to your lot already, it's just a tie-in fee. You might be able to estimate much easier, I guess. But let's say if it's a new area, where would you get this information, or how?
From the utility companies.
What is it?
From the utility companies.
You got it. Okay.
Is it still Dominion Power?
Yeah.
Dominion Power in much of Virginia or whatever.
Novak.
Like Washington Gas, Novak, Columbia Gas, Washington Gas. Call them up yourself.
And you just have to give the parcel information, and they'll be able to kind of give
usually,
you.
And there are, in some cases, there are maps As part of that binder of documents that's in the nest, I included an example of a public sewer map, Fairfax County sewer map, where you can, I'm not sure if you can type in an address on that and then zoom to the sewer map, but you can, as long as you know the map number, it's tied to the tax ID, you can zoom into the immediate street and that property, and you can see, for example, where the nearest sewer line is. When it comes to gas, I've looked for similar maps and haven't had a lot of luck. Washington Gas does have a site where you can type in an address, and it's supposed to pull up and saying, is gas available? What you see in the public record through MLS or on the county public records, you know, sometimes you'll see gas not available, public water not available, or public water connected. That's the first place I'd look, is what's in the public record, but I wouldn't rely upon that. Yeah.
So, I mean, to further answer your question too, like they're not going to give you a cost estimate to run it to your property. They'll probably give you the closest location as to that particular parcel, and then from there you'll have to have someone give you an idea. Depending
Well, they'll
on,
give you an estimate of what their cost is per foot to bring it, typically. The county itself is where you would go to for tap fees, because there's fees to the county.
Yeah.
I mean, it could be like 25 grand or whatever. I don't know what the current tap fee is to tie into public sewer. Once you have it at your property, you got to pay a tax. It's a fee to the county, Public Works.
There's a tax.
Well, it's a fee, and then you pay your service fee as soon as you know, monthly when you connect. But does anybody know what tap fees are in county, in Loudoun or Prince William or anywhere around here? I think last I looked, it was $25,000 to $30,000.
Wow.
It may have gone up. That's just a tap fee.
Right,
My
and I
question-
mean, I mean, just a quick tap on that is, I mean, when you're looking at costs, right, for say running water
Right.
or running a sewer, depending on what you're trying to do, say you're
Frontage.
building residential, you may find it cheaper to drill for a well, or you may find it cheaper to put in septic, right?
if you're
than to,
allowed.
you know, if you have the space, right? So.
My question is it by county, is a different setback frontage to front to back setback?
Yeah, you got to look at the
25
setback.
or
If you're going to build, she's talking about setbacks for your building envelope. That's another thing that is part of your study period, due diligence is, and how to price a property. Yeah, you got to be, say you have a infill lot, quarter acre or even smaller or whatever, and your buyer wants to put the largest home on that property that they can, that they're allowed to. And so there's different factors that go into play, but one of them is front setback from the street, side setbacks, rear setbacks. Okay.
So that is county by county difference?
Yep.
Or subdivision
Based
by
on the zoning, yeah.
Subdivision by subdivision also difference?
It's based on the existing zoning classification. So you can get all that information from the zoning ordinance for your given property.
Okay, thank you.
So back to
All
the
right.
contract.
Moving back to paragraph 3, so we've talked a little bit about the sales price. Now you have to determine what your client wants to put down for a down payment. That's going to depend on what their type of financing they may or may not be using. If they're an all-cash buyer, down payment would be 100% of the fee here. Financing would go into whether they're going to do a conventional loan, and also other myriads of things could fall into their financing, right? If they're buying a residential property with the intent to build a residential primary residence or a residence on the property, they could do some sort of fancy financing in regards to that, or it could be seller-based financing if you have a rich seller selling a piece of parcel and he wants to provide some sort of seller financing for your client. Some of the, I added some slides here from a Q&A with one of the First Heritage loan officers that was in-house one time. So I'm gonna kind of pop that up here. so that we can kind of look at some of the things that might go into different types of financing.
Right. So I'll speak to this real quick. As Steve was saying, you might consider seller financing, short term at least, on when you're doing a lot loan. If your people don't have their building plans, their construction plans ready to go, and they just want to acquire the lot and take their time to figure out when they're going to build, whether it's residential or commercial, whatever. A lot loan or the financing for lots is different than, it's not the best preferred financing compared to if you're going to build right away and you've got your builder and you're ready to go. So, but if that's the case and it's lot financing for 6 months, a year, 2 years, whatever, consider approaching the seller with the idea of seller financing, okay? NVAR and the other realtor associations have in their library, their forms libraries, seller financing addenda. In the NVAR library, they still have one that's called, it's an addendum to the land contract. It's a seller financing which was designed, it was labeled that it's supposed to go with the land sale contract, but it's really, I wouldn't even use it. It's old, it's still in the NVAR forms library, but they have their more recent updated seller financing addendum, which can be used for any type of transaction, not just land, but regular residential resale, whatever. Be familiar with that if that could be a benefit, because not everybody who wants to buy, let's say, and build a new home, not everybody has the ability to pay cash for that lot or the ability to put 25% down. The down payment requirements for land lot acquisition are higher typically than they are for acquisition, construction to permanent financing packages. Steve mentioned Paul Denman. Paul Denman is with First Heritage. He is one of their top construction lenders, both for this acquisition, construction to permanent financing, but he's also one of their best 203K construction guys.
And his information's in this packet too, so
yeah.
If you ever need a chat.
And
with
in
him.
the nest, I think we have links here to, in Sampson U right now, there are two, part one, part two videos of Paul Denman talking about these subjects about 2 years ago or whatever, so you can watch those. But you can get definitely 10% down. You can even get 5% down. Acquisition, construction to permanent financing with one closing. That's the advantage. It's a big advantage if your buyer wants to build. This is residential. If they have their ducks in a row ahead of time, if they've identified a builder that they want to work with, they've got basically a plan, house plans that they're just about ready to go with, because you're going to need that to get construction financing, to get that type of preferred financing. And it's typically interest only, I believe, on the lot acquisition portion. They advance enough for the lot acquisition, and then as the building permits are obtained and the builder is ready to go, they do draws. The same lender will advance construction draws based on a schedule, based on the plans and the approvals with the county. That is also typically interest only. And then when you're done with the house, you get the residential use permit, that lender would implement typical, say, 30-year fixed amortized financing. And often it's at the same rate. It can be all at the same rate. So it's not like you're necessarily paying a super premium on the interest rate for the initial acquisition and the construction part. It can be the same nice long-term fixed rate that you're going to end up with. Mm-hmm. They call it takeout financing.
Also, the title company will do bring downs when you're building on that land to make sure that there are no liens filed
That's
during that time frame. So I just wanted to mention that.
Yeah,
And
you got to be, you want to plan ahead and know who you're dealing with your title representative. And, we obviously encourage everybody to speak with management at Cardinal Title, if you would consider Cardinal Title on a lot acquisition, construction to perm deal, because it does require a different level of expertise and management responsibility on the part of the title company, because they have to act as mechanics lien agent and do these title bring downs. So effectively what happens is they get the money, or before the lender will release the money, each draw to the builder. They rely upon official waivers, these mechanics lien waivers, to make sure that materials have been paid for, that no contractors have filed mechanics liens against the title.
Right. And then just one other comment from here too on First Heritage. He made a comment that they don't do like lot acquisition only. So
First Heritage does not.
right. So if you have a buyer that's not ready, they want to buy a piece of property, but they don't want to build on it yet. They don't have the cash to buy it outright. They may need to go seek financing either from like a credit union or a small, like a bank or something like that, in order to solidify that loan.
Right. And there are plenty of such credit unions and some local banks who are happy to do straight lot loans. But First Heritage and a lot of the lenders that we're familiar with, Intercoastal, First Heritage, these different traditional mortgage lenders, correspondent lenders, they fund the loans and they package them and they sell them within 30 to 60 days. It's just not their business model to do lot loans and to hold them.
Yeah, and these were just some questions and answers that I posted on here that Paul had with the crowd. So I posted them in here, but I think Mike already touched on them.
Yeah, a little bit on interest only, a little bit on down payment, average down payments. Some banks will do as little as 10% down, depending on the type of deal. So all of this is in your packet, and it's also what he talks about in the video that's in the nest.
Right. And then going back to
one more thing, I'm sorry, on the contract with the financing,
Yep.
with the contingency, what I would recommend you do for sure is, so on your price and financing, where it talks about paragraph 3C in your packets, I would be checking there for your first if this is a lot acquisition, construction to perm deal, I would be checking conventional, but then under the box, I would also check other, and I would write construction, or acquisition, construction, because you want to make sure that your contingency, if you've got a financing contingency, that it is specifically for that's being the specified financing, which is a defined term in the contract, so absolutely make sure that you clarify right there that it's the intent of the buyer, the financing is not just lot acquisition, it's acquisition/construction. Okay?
Yep. Then on paragraph 3, you also have room for a seller subsidy if you're asking the seller to pay any type of subsidy. Also, like all of our new contracts, we also have the seller paid buyer agent compensation field if you're asking the seller to pay commission towards you as the buyer. Paragraph F goes into your financing, whether or not it's going to be contingent on financing or not. A lot of people wrap everything into the study period, but it's always good to have a separate contingency for your financing.
Now, is land cost to buyer, closing cost will be different than residential amount? What percent? Sometimes we say buyer, if just normal financing is a 3% of
That's a
what
good
is the
question.
closing cost?
You know, it's you're gonna there's this grantor's tax paid by the seller. There's recordation tax for your buyer for the
Similar.
the deed of trust and the note. So it's just going to be based on value. But I would say you should still use about 2.5%.
Similar to residential.
I think so. And it depends on whether the buyer gets owner's title insurance, which we recommend always,
Yes.
not just lender's title insurance. And if they pay cash for the lot, because a lot of times you'll have people that have the wherewithal to buy the lot in cash, and then they're going to take their time and they're going to get construction loan and permanent financing eventually. But doesn't matter whether they pay cash or they finance it. We would recommend owner's title insurance, but that's an optional part of the costs.
So next paragraph is still in paragraph 3. You have your appraisal contingency, whether or not you're making the contract contingent on an appraisal, or if you're not making it contingent on an appraisal, whether or not you do want to have the seller provide access to the property for a potential appraisal. Same as your residential sales contract here. We also have our deposit paragraph, which gets into how much are we putting down for our deposit. And I lost my page here.
On the appraisals, real quick, you'll see at the end of this packet there's at least one recommended land appraiser. Be aware that a land appraisal can be more expensive, obviously, and the more acreage you got, or if there's anything unusual about this property, or especially if you're trying to get an appraisal, like in conjunction with a feasibility study. If you're trying to get an appraisal on highest and best use, what's the potential value of this? And you're paying, or your buyer's paying an appraiser to do that, you got to find a specialized, experienced appraiser, okay? And that's residential, commercial. If you're talking about a future value appraisal based on subdivision into a certain number of lots, or upzoning to a higher density, or okay. And if you pay cash for a lot, you can obviously still have an appraisal contingency if your buyer wishes to. And in the NVAR library, and I'm sure in the other forms libraries, there is an appraisal contingency all cash addendum that's available.
Okay. So then paragraph 4 is your deposit paragraph. Here is where you'll be noting what your earnest money deposit is in regards to putting that in for your deposit. Who will be holding that? As we've talked about in other training classes, Sampson Properties Policy, or Sampson, we prefer that our agents deposit with Sampson, especially with their buyers. It offers our buyers more protection if the deposit is held by Sampson. We still have a lot of folks that still deposit directly with the title company, which is fine. However, there's certain things that the title company can't do that a brokerage can do if you get to a position where the seller is adamant against not releasing the EMD, even though the buyer void under circumstances that they had a voidable option to do so. So it's one avenue that the brokerage has that a settlement company doesn't have. So consider protecting your buyers just a little further by depositing your money with Sampson.
We've heard that a lot of our agents have come from other brokerage firms where the brokers said the opposite and always advised that they didn't want to be the escrow agent. All things being considered, title companies and real estate brokerages would rather not be the escrow agent, all things being equal. But I believe, and I've always believed, we believe that when we represent the buyer, we got to protect and promote the best interests of the buyer, and there is a state law provision in Virginia and in Maryland. I can't speak to West Virginia or Delaware or some of the other states. I'm not aware of the same provision, but it is a provision that can benefit our client. When Sampson is the escrow agent, it has proven to benefit our client many times. And so why not do that? Unless the listing agent says, no, we want the money to be held by the title company, not by your brokerage. Escrow rules still apply. I mean, you can't, nobody can release funds willy-nilly from escrow, but
That's
more often.
That's a good lead-in too.
Yeah.
There's only 4 ways.
Willy-nilly?
There's only 4 ways to release that money.
Yeah.
Right. So we shouldn't tell our clients that if the buyer defaults, we get the earnest money deposit. Right. So there's only 4 ways to get. There's only 4 ways to release that money. Right. Outlined here in paragraph 4 is 1, credited towards the sale price at settlement. All parties have agreed in writing to the disposition. So that would be everyone signed a release. A court of competent jurisdiction decided the outcome of those funds. Or 4, the disposal in any other manner authorized by law. So nowhere in there did it say the seller automatically gets that money, which sometimes is a misconception out there. So we have, sometimes sellers are very quick to pull the trigger on putting a buyer into vault, thinking that they're going to get the earnest money deposit. So make sure your clients understand that it's not that, sometimes it's not that easy, right?
Right.
So.
Maggie, you have a question?
You have
Who's got a microphone?
Coming to you.
Thanks.
One's coming to you.
We got you.
2 are coming to you.
I was just looking at this deposit paragraph when you were talking about it, and I thought, well, what would be a way around that? And you could always check off has delivered and already have it at the buyer's broker when you write the contract. Can't you do that? So that if it's already with the buyer's broker and the listing agent doesn't like it, you can say, oh, well, the deposit's already there.
I mean, legally, sure, you could write it. That's why that option's there, I guess.
No.
We don't want, just so everybody knows, we don't want deposits turned in here until there's a ratified contract, though. Okay. But, and, you know, by the agent having the check in their hand or whatever, if that's the case, if you're holding the check, not really the same thing as has delivered to escrow, to our account. Another thing on the deposits that comes up with land, especially if you're, this is tied into studies. We'll get to the feasibility studies, but staging of deposits is not uncommon. If you have a feasibility study, especially if it's going to be, if it's a project where you're seeking subdivision or special use permit, certainly rezoning. Often what you'll find is you'll see a modest amount of deposit with the contract when it's ratified. But you could have terms in the contract. As a buyer agent, you could say, we will give you more. This is what we're putting up now, but we've got a study period, and it's whether it's 30, 45, 60, 90 days, whatever the study period is, we will give you more. We will deposit additional deposit funds at a certain milestone, whether, you know, when we remove our study, or we'll put up X amount when we remove our study, and then we'll put up more when we get preliminary approval from the county on this concept development plan or whatever. So it can be staged where you're trying to, the buyer doesn't want to have more skin in the game with hard cash than they need to. You know, listing agents will sometimes say, if, you know, we want more earnest money, and if you're not willing to put it up right now, we're going to counter your offer and say you got to put up more, and it's going to be quote unquote hard. It's going to be non-refundable, some of it or all of it at a certain point in time, if you don't walk away, if you haven't walked away under your study. Okay.
I have a question. Regarding deposit, how many percent do you recommend it? For residential, usually they said 1 to 2%. Is the land same?
You know, I would say probably, yeah, 1% minimum as a buyer. But it depends. I mean, depends on the deal, and if it depends on your buyer. That's your buyer's decision. But we would recommend, you got to show some amount of seriousness with your offer, I think, depending on how much you're trying to negotiate.
Question regarding study period. How long do we typically put days in there as far as the study period to be done?
That's a great question, and we're going to be coming to study period here shortly.
Okay.
So please hold that
We've
question.
been touching on study period items or issues. We understand that.
It's only we're at paragraph 10, so
we're getting
almost there. So
Hi, Joy.
if I can move this guy along, no, I'm just kidding.
Sorry, I've never heard of the staging part for the EMD.
Deposits.
Yep. How do you do that? I mean, how do you show that in the contract?
You just write it into the, on an addendum or whatever.
Okay. That's what I wanted to know.
I mean, just wanted you to be aware of it. You might not offer that as a buyer agent. That's more of, you know, when you can do this with builders too, right? With new construction, custom builders. Say, I'm not giving you, you know, you're asking me for this big fat deposit. I would like to negotiate something different in the way of staged deposits as we move forward together.
Right. And that would be like anything. The seller's always wanting more, right? And the buyer's always wanting to put put up less.
Right. And if you're, you know, depending on the deal you feel you've struck as a buyer agent, if you know, you're in your study period and or whether you have a study period or not, if your buyer really, really wants it and you are making an aggressive offer, low offer or whatever, a hefty deposit can help win that deal. Or making it non-refundable. It's like, you know, each deal's different.
All right, paragraph 5 is settlement possession. So here, just like on your residential sales contract, you're going to fill in a date, but you have to be a little bit more thinking ahead, right? It's not as simple, right? 30-day closing or, you know, quick closing or whatever. It could be, but depending on what you're going to do in a study period to make sure that land is going to do what your buyer wants it to do, you may have to use some forethought and say, okay, we're doing a 30-day study period or a 60-day study period, so we're not going to be able to settle until after that. So make sure that you don't put TBD in here. So try and come up with a date that corresponds to what you may have to do with that buyer.
Yeah. You want to have enough time minimum, especially if you're financing it, to get to closing after the last day of your study period. If you take your feasibility study period right up until that deadline, and you said, okay, we're moving forward, we're not going to void, make sure you give yourself enough time for your title and lender to get it done.
Continuing on in paragraph 5, you have your buyer notice to the seller, who they're designating for settlement. This is just a little plug for Cardinal Title. So if you haven't used Cardinal Title, please, did you like that?
Yeah.
I'm getting pretty good at this stuff. You want to go back so we can do it again?
Yeah.
All right.
No.
So Cardinal Title, if try and give them your business, it helps the whole machine here at Sampson Properties roll. It helps pay Mike's salary. So if you like talking to Mike and want to keep him around, you know, otherwise you'll just have me.
Yeah, right.
That might not be so good for you.
I'm taking him to lunch today. And again, so Cardinal will definitely do lot acquisition loans. I mean, unless it's down in, you know, Booneyville, Virginia, way down. But whether they will be able to do lot acquisition, construction, perm, financing package, I would check with Reed Hubbard or Rob Bodine, one of the attorneys, Kerry Lindsay. Okay.
All right. So then paragraph 6 gets down to your down payment, what that balance is. Everything is due at settlement. Number 7 is brokerage fees and settlement statements. This just kind of outlines the seller and buyer authorize and direct the settlement agent to disperse to the listing agent and the buyer agent at settlement any respective commissions. And then paragraph 8 gets into fees and adjustments. If we're doing contracts on residential side, we all know what that is. It just lets the buyers and sellers know what fees they may have to pay. And then paragraph 9 gets into land use, assessment, and rollback taxes. So I highlighted this one and kind of bringing it out a little bit because it's kind of a paragraph we don't really want to skim over. So land use, assessment, rollback taxes. The seller represent that the property is or is not currently enrolled in a land use assessment program. If by the actions of the seller, property is deemed unqualified for land use assessment program, seller will be liable for any rollback taxes. If buyer declines to continue the property in the program or fails to renew or revalidate property in the program after settlement within the time frame required by the local regulatory authority, seller will not be liable for the rollback taxes. So on certain parcels and certain agricultural, mainly properties, they may, the current use may be getting a tax incentive to utilize that property for whatever they're doing with it. So if you continue the same usage as the buyer when they buy it, then the buyer and they keep enrolling in that same program, then they would enjoy the same tax benefits. Otherwise, if they don't, they could owe back
Recapture.
taxes. Right.
Recapture tax. Yeah, we talked about this last time a little bit from the perspective of a listing agent. I just want to say it one more time. If you're a listing agent, do your homework. I mean, ask your seller first, but also, don't skim over it, because what I don't think is a good idea is for any listing agent or seller who knows that they're currently benefiting from land use rate, preferred tax rate, and they know that there could be recapture tax, to not just be upfront about it. That's why it's in this contract. You don't want to try to pull the wool over the eyes of your buyer. I mean, it's going to come up, and why have a deal blow up at the last minute over that issue? Because chances are, it's going to become an issue right before closing if it's not addressed early on. So, and in the full binder packet that I have in the nest, I know there's a link, for example, to the Loudoun County Land Use Program websites. A lot of the counties have their information readily accessible, including instructions on what sellers should be doing annually to renew, because they're supposed to update with the county each year, I believe, in most counties, their eligibility for that reduced tax. And then also, if you're going to sell, the buyer may, the parties may want to have the buyer fill out a form telling the county in advance, yes, I'm signing here saying that I'm acquiring this property and I'm going to keep it in a eligible preferred tax use. Doesn't have to be the exact same preferred class that the seller had, but if it's one of the available land use classes, so that the buyer can continue to benefit, plan ahead for that and make sure your buyers are aware.
I have to confess, I have not heard the rollback and go back to learn about more since the pre-licensing, nearly 30 years ago.
Yeah.
Would you please explain, if everybody knows already, that's great, but if not knowing what exactly rollback tax is,
So-
that is very important to me.
Thanks. To summarize it happens more often than you might think, even in our super wealthy suburban area. I mean, because you have these little farmettes, these little, these, what do we call them?
Family farms?
Family farm. You can have a couple of goats or horses or chickens out in where it's allowed in the zoning, or have a little farmer's market where you're growing some produce or whatever you're doing, or you can have Christmas trees, or there's a lot of different qualifying uses for these that's happening right now in Loudoun County and Fauquier County and some
Winery.
wineries. It doesn't have to be a huge production. You don't see it as much in Fairfax County or Arlington, or right, but CC in the packet online, there's a link to the Loudoun County, or just Google Loudoun County land use program, okay, or rollback taxes, and you'll get it. It can vary a little bit county by county, but it's nothing more than the parties want to be careful as to the potential for recapture of tax that was deferred. It was because the seller has benefited from a lower tax rate, and when that property transfers to a new buyer, if that buyer is not going to keep it in that use or a similar use, then somebody might have to pay. And well, that's what that right there, paragraph 9. Who's paying for it? Does it? Well, it says, is it or is it not currently enrolled in land use assessment program? Doesn't it further say who's
No.
paying? So this, yeah, you want to make sure if that's checked.
Well, it does say seller will be liable for the
Seller.
rollback taxes. If buyer declines to continue property in the program or fails to renew or revalidate property in the program after the settlement within the time frame required by the local regulatory authority, seller will not be liable for rollback taxes. I think it could be 5, I think.
Yeah, up to 5 typically.
Right.
So research that if you like, but especially if you're dealing with land.
I've got a question back here.
Okay.
Yeah, you were just touching on it right now. So the rollback taxes, that's something. So let's say a client closed on a property today, and they're going to change the usage of the land, so they're going to be responsible for these rollback taxes. That was my question. How far back will they have to pay? It's not started that day, or the time that they make the actual change to the property, or is it go backwards?
I would say check with the county, the applicable county. I can't speak across the board. Okay?
Well, right. Yeah,
Any thought?
I think it's maximum. I think the way it says in the code from some of the material that we
Maximum
had
5.
last year was they could go back as far as 5 years in taxes. So the buyer, if they decided to change the use, that would be something that they would want to investigate during their study period in regards to how much rollback taxes they would be on the hook for. And then if they did decide to buy it and change the usage, they may want to incorporate that into their price point as well, right?
So,
Or ask seller to subsidize, right? But I mean, if the seller is using it for a certain purpose over that period of time, and now the buyer's coming in and they want to change the land use, well, theoretically, why should the seller pay for that, right? I mean, they used it as, right? But
It's all negotiable.
It could be up to 5 years. It doesn't necessarily mean it would be 5 years, right?
So let me get this straight. As long as the buyers doesn't change the use of the land, then they can continue benefiting the tax,
That's right. But they would have to qualify for
They
it.
have to qualify for
Yeah.
it. So as a
Annually.
listing, if I'm representing the listing sellers, so how can I protect my client if the buyer says we're going to continue on because he said they need to apply for it and all of the stuff? Because at that point, how do I protect my client?
The protection is in this contract, right? So it
So-
says that if the buyer declines to continue the property in the program or fails to renew or revalidate property in the program within the time frame required, the seller will not be liable for rollback taxes.
Okay, so
So-
they will gonna come after the buyer.
So the buyer, that would be the buyer's responsibility. If
Okay.
they somehow missed their deadline or
Yes.
somehow did whatever, then it would be their responsibility.
So the last sentence, it says seller will not be liable for rollback taxes. So
Right.
that's always the case. That's a standard.
No, that sentence is referring to that's a comma, right? So that is referring to the buyer declines. So the whole sentence is in play here. The buyer declines to continue the property in the program or fails to renew or revalidate property in the program after settlement within the time frame required by the local regulatory authority, comma, seller will not be liable for rollback taxes. So the seller could be liable for rollback taxes in the previous sentence, right? If by the action of the seller property is deemed unqualified for the land use program, seller will be liable for the rollback taxes, right? So that would be when the seller would be liable, but if the buyer decides to not continue on or fails to file the appropriate paperwork, the seller is not responsible for that rollback, any rollback
And you
taxes.
you could supersede it or emphasize further if you wanted that if you're a buyer agent, in no event will buyer agent be responsible for any seller rollback taxes attributed to the ownership period of the seller. You could add that for additional clarity.
Yeah.
Okay.
All right. So is there a drum roll? Paragraph 10, the study period contingency.
Now that we've covered most of it.
All right. We're going to move on to the next. No. So paragraph 10 is the study period contingency. Here, it says the contract is contingent for X amount of days after date of ratification for the study period for buyer to determine whether property is suitable for the buyer's intended use, feasibility, soil, utilities, percolation studies, or any other studies or tests deemed necessary by the buyer. Such studies or tests will be pursued diligently and in good faith. If buyer's sole judgment deems the buyer's intent use of the property is not permissible or practical, buyer will have the right to void the contract, in which the deposit will be returned to the buyer and the parties will have no further liability or obligation hereunder except as set forth herein. In such event, the buyer will or will not deliver to the seller all documents related to the tests and or studies conducted during the study period. So here is where you have to decide what you're going to do. If the buyer does not void contract by the study period deadline, this contract will remain in full force and effect with no study period contingency.
So mark your calendars, buyer agents, right? This is just like any other contingency, like a home inspection contingency. You got to remember your deadlines. Don't let it get by you.
And then the last paragraph, all engineering, survey, topographical maps, site plans, special use permits, soil testing data, and any other technical information affecting property in the possession of the seller will be made available to the buyer within X amount of days, or will not be made available to the buyer. So
if you're a buyer agent, you definitely want to check, yes, it will be made. Whatever the seller has, you're saying that the seller is obligated to give it. You don't know what they have, so how can you really enforce that? But contractually, that would play to your buyer's benefit if you're a buyer agent. Hey, seller and listing agent, whatever studies you may have paid for in the past, whatever you have that reasonably could benefit any buyer, we want them, okay?
true.
By the way, I've suggested to people on occasion, depending on the type of property they're going for, that that study period language right there, you can cut and paste that onto a blank addendum and use it with any contract. Like a residential sales contract that you're trying to decide, are you going to tear it down, are you going to renovate it, what are you going to do with it? Rather than having a home inspection contingency addendum that has its language, and that's good language with the negotiation period, buyer election period, all that. This is has its merit as well because it's a blanket coverage walk-away clause for any reason at all that the buyer might want, okay?
So talking points along with that study period?
All right, let me read through these. Again, most of these or all of them are going to be on that outline form. Feasibility study period covers any due diligence you deem necessary and gives you sole authority to cancel the contract or to attempt renegotiation based on the results of those studies. And so, Each deal is different. Obviously, you're a buyer agent, you're working for the buyer. Listing agents need to be aware of this too, of course, that any study period has the potential for renegotiation. And it also has the potential for the buyer to say, well, we thought we would be done with our due diligence by now, but we're not. And we're asking for an extension to the study period, okay? So that's not uncommon. Exactly what studies you choose to conduct will depend on your intended use of the property and whether the seller has already done some of the work for you. For example, the seller might have obtained perk test results with or without an official county septic certification letter prior to listing the property, in which case you may not need to conduct your own soils test. Any seller-provided surveys, engineering reports, etc., are valuable. Okay, so ask before you write your offer. Okay,
And a good listing agent will put all that stuff in the document section for you. So,
and a good listing agent might also be prior to going on the market. Well, perhaps well in advance of going on the market, listing agent should be talking to their seller about whether any third-party expert tests, perk tests is a prime example, or any engineering proposal, feasibility study on a seller side. You'll usually only see that when they're talking about higher density subdivision, rezoning, commercial uses, etc. So what does the county long-range plan call for in the context of allowable zoning, density, uses, potential changes to adjacent and nearby properties, etc.? Comprehensive plan is updated periodically. It's not updated that often. It doesn't seem like it's updated all that often. I don't know what the interval is in our local counties, but you can go right online and look at it. You can look at the map and see the whole county, and it's keyed, color-coded and keyed based on not only what is likely the very current zoning for any particular property in the county, but what has the county already determined that's what they want. And to do anything different than what's on the comprehensive plan, you'd have to, at a minimum, probably get a rezoning through, maybe what's called an amendment to the plan. And that's where your costs go up. You got to have sophisticated legal teams, engineering and legal teams. So are there any wetlands? We've talked about this. Are there any wetlands on the property? If there are, you can use the study period to obtain a wetlands delineation report, environmental study, resource conservation report detailing any related development restrictions. Probably you all have heard of conservation lots, like in some of these nice estate communities out in the suburbs. You have developments that were approved, and certain homeowners, Danny Sampson's one, who was able to acquire some pretty nice additional acreage adjacent to his and Gail's home site, primary acreage. He bought these additional lots, but they were conservation lots, never to be built upon. Buffer land, parkland, whatever, right? And that's in the deed. It runs with the deed.
or golf course.
So you can also use the study period to collect and evaluate quotes for your anticipated project costs, like engineering, legal, municipal, utility, site work, such as clearing, road, or driveway installation, in addition to any new construction. You're obvious, if you're going to build residential or commercial, you got to be thinking about all of that. Your buyer has to be thinking about all of that. And the further along they are before they make that offer, with connection with a builder, with engineer, having some idea of what's involved in these things can help them when it comes to their offer. Mm-hmm. But definitely that's what the study period's for. Whatever studies, let's see, where are we?
Last one.
Whatever studies you do decide to do, try to find out how long your engineer and or contractors will need to complete such studies, so you know how much time to negotiate for with your study contingency. In some cases, could be as little as 15 days, just like a regular home inspection. 15, 30, 45, or 60 days may be sufficient, but it could also be considerably longer, up to a year or more, depending on the scope of plans for this property, including any need for subdivision, rezoning, et cetera. So it can run the gamut. But I've seen, I mean, you know, I'm sure some of you may have experienced this. You've got a listing in the town of Vienna, or, you know, in a more hot, quick turnover area, infill lots, these tear downs. Builder will come in there and maybe have no study period, or he may only have a 15-day study, because it's pretty obvious they're going to be able to do what they want to do with it. They might be able to get by without any study period at all. And as I said, there's one example, just one example of like a feasibility report in the nest, in that binder package. This goes through the various considerations that anybody would have to do for, in this case, a very simple subdivision candidate, just taking 4 acres and trying to get 3 lots out of it. That's what this was about, okay?
So I know you guys are disappointed, right? Because he didn't tell you an exact number of days for a study period. So it could be
Depends
variable,
on what you want to
right?
do with it. You could find out everything you need to know about this piece of land in one day or 2 days. I highly recommend that all agents that are involved with clients, whether you're a listing agent or a buyer agent, or if you're a principal and you're doing something for yourself, go to the county. I mean, you'd be crazy not to. Go to the county offices, to the zoning people, to the building and development people, the environmental health, public health offices. These people will, you can call them ahead of time and say, what's the process? Do I need to make an appointment? Can I meet specifically with a designated engineer of the day or staffer? Or do I just walk in? What's the best day to come in? Because sometimes you go in there in the morning, you might be waiting in line, because there's a lot of entrepreneurial people looking to get approvals for all kinds of things with our counties. But those people are there to help. They will open up their maps and their all the resources that they have right there in front of you. You can make copies of stuff while you're there. I encourage you to do that with your client, or if not, definitely go yourself. It's every time that I've done it, it's been a good learning experience. At a minimum, you need to say to your people, do this, go. I mean, we don't have a license requirement to be there with them, but for full service, professional service, it's there's no substitute, and that's all fundamental, preliminary. From there, you might need to decide, okay, do we need to bring in an engineer or appraiser, other experts?
Any questions on the study period? Man, good job. Good job, Mr. Briggs.
Yeah. And like we said, within the next 30 days, I believe, we will hopefully announce that we'll be in here with John Manganello. I've got links in the back of your packet. There was a few recommended service providers. He's one of them. There's another engineer. You know, depending on where you are, if you're up in Maryland or down south, you're going to likely want to identify people that are more local. Those people are tied into the county staff, and we all know that good old boy networks or good old girl networks still exist in some parts, and to have an engineer or a soils guy or lawyers that are familiar with, connected to county staff, that can help. That can definitely help. So,
All right. And then the only real difference left in this contract for unimproved land is paragraph 12, which is the hazardous materials paragraph, which talks about the seller hereby expressly represents and warrants to the buyer that during the period of the seller's ownership of the property, seller has not used and the seller has no actual knowledge of other uses using the property of any portion for landfill, dumping, or any other disposal activity or operation, including storage of raw materials, products, waste of hazardous nature, or for any other use which might give rise to existence of hazardous material as defined by, but not limited to, the Resource Conservation and Recovery Act and the Comprehensive Environmental Response, Compensation and Liability Act, or by any local ordinance on the property which would create a liability for the buyer. The seller agrees to identify and hold buyer harmless for and against any and all costs, expenses, and liabilities which may be incurred by the buyer, including without limitations, court costs, attorney's fees, blah, blah, governmental agencies, as a result of any breach of the representation and warranties of this paragraph. Seller and buyer will not hold broker liable for any breach of this paragraph. So this is just pretty much outlining the seller. So make sure you understand that the seller, and you could probably have this checked during your study period, is that it was not used for any type of hazard dumping, waste dumping, or anything of that nature.
You see these environmental studies with commercial and industrial land, of course, a lot more than you do with residential. But one of the links in the package might be for Ed Donofrio. Some of you all know Donofrio and Associates, home inspectors that we've recommended. We love them over the years. But Ed, the Grand Poobah founder and top guy there, Ed Donofrio, does commercial and industrial inspections, but also these phase 1 studies, environmental studies. Any property that you have reason to believe in the past, including some farm property, if there was gasoline tanks, oil tanks, if it was used for any kind of manufacturing or industrial purposes, that might be a candidate for an environmental study. And sometimes the counties will require it anyway, especially if you're going to submit for subdivision or rezoning or whatever. The county often will require an environmental study. Okay. So, is that it?
That was it on that.
Good.
And then just perusing through the contract, getting to the additions to the contract. I mean, all this stuff is really the same as your residential sales contract, so I'm just kind of breezing through it. And then when you get to the additions to your contract, a lot of the same additions here for contingencies, clauses, addendum, if it's an as-is type sale. Your finance and appraisal contingency stuff in here, as long as a residential property disclosure statement. Now, when would a residential property disclosure statement be required? Theoretically, only on residential.
If there's a dwelling.
Right.
If there's an old dwelling on the property, even if it's likely to be a tear down, use the residential property disclosure statement.
Right.
Okay.
So, and then extension or review period for any common interest. So if a property is sitting as part of a property owners association and you need additional time, any addendums to the contract or other, that's pretty much it. And then the last page is standard boilerplate stuff from your residential sales contract as well. Any questions whatsoever regarding some of the stuff that we covered today? All right.
Thank you for coming.
Thanks for coming. Thank you, Mr. Briggs.
Thank you, Steve.